In this presentation, we're going to be talking about interrogatories and requests for production of documents in the context other than divorces. So, we can break down divorce and post-divorce matters into several different categories and types of interrogatory questions. We have standard questions that could be asked in every case. We have divorce and alimony related questions, money, grounds, custody, child support, attorney's fees, and then case-specific interrogatories and requests for production of documents. Now, what I'm going to do is go through our divorce interrogatories and requests for production of documents, talk about each, and give some tips on how to prepare a set of interrogatories and requests for production of documents in a non-divorce case. And usually what we're talking about is either a custody modification matter or a child support modification matter, but not always. All right. So I would think an alimony modification, post-divorce action, we're going to be hitting pretty much just all the same divorce information that's already in our interrogatories and requests for production of documents. And that we're just going to cut out custody and anything related to child support. Okay, so that's not that complicated. All right, let's go through them. So what we're working through is our, as of what is today, December 14th, 2020, our sample set of interrogatories and requests for production of documents that we have for divorces. All right, state your full name, any aliases or nicknames, current address, date of birth. Now, we do that in divorces because we're looking for aliases and nicknames, and we want that answer under oath. What if the opposing party has another identity? All right, it's weird, but it's so basic, we make it number one. Please identify by name, address, and telephone number all individuals who have discoverable knowledge of any relevant facts. All right, now in that, we want that's one of our standard or general ones. We want to include in this matter, but of course we need to tailor that, referring to grounds, assets, liabilities, income, or expenses. If it's a post-divorce custody, we need to fix that, of course. So interrogatory number one, aliases and nicknames, probably ditch that for a post-divorce matter. Interrogatory number two, we keep. Now, interrogatory number three, please identify the name, address, and telephone contact numbers of each expert witness. Again, that's going to be a standard in general. You never know when there's going to be an expert, so that's what you dadgum need to have that in there. Interrogatory number four, please identify specifically any reasons or grounds why you or your spouse should be divorced. Now, obviously, this is a divorce question, all right? But it's a quasi contention interrogatory. And if you need to look up what a contention interrogatory is, please do so because you're expected to know. In short, a contention interrogatory is essentially why you should win, or the other party should win, the divorce, custody, child support. Okay. Now, in general, contention interrogatories have two different concepts associated with them. Number one, if you don't do depositions, in theory, the other side should have to answer the question fully and completely, or risk not being able to enter in evidence that supports their position by failing to answer the contention interrogatory. For example, list all reasons and grounds why you should be primary residential parent or parenting time should be modified. Okay? So keep that in mind. The opposite is if we're going to do a contention, if we're not going to do a contention interrogatory, we can take the party's deposition and ask them, ask the opposing party that a series of contention interrogatory type questions and they'll have to answer them on the fly. Now, in family law, when a party cannot articulate the legal reasons why they should prevail, generally courts give them a little bit of leeway on that because they're not lawyers. Okay. So, for example, if we're taking a deposition and they say, and we ask the opposing party, tell me every reason why you should be declared primary residential parent. And the opposing party says, I don't know. Do we automatically win the lawsuit? No, because the opposing counsel has 5 different ways to get their client out of that mess. But you ask them, have you ever sent my client ever a copy of the children's health insurance cards? No. Well, they're going to remember whether they sent over the health insurance cards. And when our client testifies that they asked for it 42 times, we got a pretty good argument there about an unwillingness to co-parent. Even when one parent is providing all the health insurance premium and coverage, they're not sharing the ability to use it with the other spouse. Judges hate that. Okay, so we could ask them also at the deposition, isn't it true that my client requested the health insurance card from you 42 times over the last 16 months? And we may have that counted up via email, text messages, whatever. Okay. So that would be something that the lawyer or lead counsel on this matter is going to consider. Do we want to ask a contention interrogatory or just use that key point at a deposition, see what we got, holding that back, right? Now, interrogatory number 5, please identify any financial statements, net worth statement, or list of assets and liabilities pertaining to your property or financial affairs. Now, the reality in custody cases is that the relative financial position of the parties is indirectly / directly a factor. There's no factor that says the wealthier party gets custody. And in fact, they say you should decide custody not based on wealth, but resources to be provided for the child is still a factor, okay? And if you got money and you got a better house and you got a pool and you're already paying for tutors and educational assistance, well, we're going to want to talk about that. If it's a situation where the primary residential parent hasn't been paying for or otherwise subsidizing something important for the child that the other parent can pay for and is contributing to already, like some type of psychological educational help, say with dyslexia, well, the money becomes more important, but it's still a little bit tangential. So we've got to decide early on, is this a theme or a theory in terms of who has more money for custody? For child support, this is obvious, okay? Because on all loan applications, whether it be for a car, truck, home, the party's going to state what their income was. Now, they may not have kept it, but every time you go to a car dealership, one of the first things they ask you as part of the loan application process is, what's your monthly income? All right, if we can get that from a dealership, that'd be great. Or a loan application for a car loan. We should be able to get it straight out of a subpoena for a home mortgage application. All right. So for custody, we may not want to go that route. For child support, we're always going to want the financial statements. Okay. List all employment held by you for the preceding 5 years. Again, obviously for child support, we may want, if we're modifying child support within the last 3 years, make it the last 3 years. Maybe 4, maybe add a year. But for custody, how does employment become relevant for custody? Very simply. What if the one of the parents can't hold down a job and is unstable? All right, they're living half the time they're in a double wide with cousin Bob. The other half of the time, we can't figure out where they're staying. Okay, so that could easily be employment could easily relate to custody. Preceding 5 years, if you had any source of income other than from your employment listed above. Yeah, I like that for child support, maybe for custody too, depending. Same rationale. List all non-marital property claimed by you, divorce only. List all marital property, the marriage, divorce only. So delete those, like that. For the preceding 5 years, the length of the marriage, whichever is longer. This is interrogatory number 10. List the name and addresses of all associations, partnership, corporations, blah, 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 business entities. Definitely want to do that for child support, and we may want to do it for custody. Who knows? Depends on the facts and circumstances. Interrogatory number 11. Have you had any account or investment in any type of financial institution, including but not limited to internet payment accounts, PayPal accounts, Amazon.com accounts, Venmo, etc.? So again, financial assets, obviously very relevant to child support, arguably relevant to custody, but not always. Right? Number 12. Identify any right, title, claim, or interest to a pension plan, retirement, or profit-sharing plan. Now, we may leave that in for child support. What if the other parent's got a 401k, and we got to figure out what their income is, and we want to include the 401k contribution, even though it's not taxable? And that's where we get into the box 1 versus box 5 of the W-2. And we have a separate blog post online that's very popular if you want to check that out. All right, interrogatory number 13. Has anybody held cash or property on your behalf? Probably not, never relevant for child support, for child custody, possibly relevant for child support, but mostly a divorce question. So if you're running short and you want to delete that one, great. Interrogatory number 14, outstanding debt or financial obligations, credit cards. Yes, if I'm a judge, I'm going to take seriously whether somebody can pay their own bills or not. If they're behind on child support, and yet they're still putting big expenses on credit cards, I want to know that. And if I'm the opposing party, I want to know that too. All right? So, to me, and I don't know that this would necessarily fly in a courtroom, this argument, but the number one way we know about people is through their choices. People can say whatever they want, okay? You know, somebody can have a big MS-13 tattoo all over their neck and say, yeah, I'm a police officer. Well, I'm going to really question that. People could say anything, but I want to see the credit cards, because our life choices, in my opinion, many times are reflected in our spending. Okay, and you can find out: are you is the other party a "I got to have it now, even though I can't afford it" type person? Which you might see if they're leasing a brand new Mercedes when they're having trouble paying their own bills. Because yes, there are financing companies that will loan money, and that's what a lease is a loaned vehicle in exchange for a flat fee, because of the security on the vehicle. So just because they drive a fancy car doesn't mean they have money. All right, and that's why I want to see those credit cards. 15. are you owed or have you been owed any money or property? Very good divorce question. Probably not good for custody. It's a big maybe for child support. Again, that's going to be individual judgment. Have you purchased any real estate? Obviously, that would be good for child support. Have you made any gift of cash or property? Maybe not relevant to either, actually. Unless you hear a rumor that they've made a gift to a neighbor or a girlfriend to hold money for them, or a boyfriend. Now, have you made loans to any person or entity, not your spouse, in an aggregate amount of more than $100? Well, we may want to find out for custody or child support, maybe move that up to $1,000. Okay, and then that interrogatory, we do need to change it to read former spouse or current spouse. Now, interrogatory number 19. Have you sold, transferred, conveyed, encumbered, concealed, damaged, or otherwise disposed of property owned by you? Probably not relevant to either one, so delete it. Have any appraisals been made with any property? Probably not relevant to either one. Another question regarding real estate, interrogatory number 22, life insurance. Now, you may want to put that in there if both parties have a duty to insure the children. So while you're in discovery mode, and if the permanent parenting plan that's already been entered includes a life insurance policy obligation, throw it in. Can't hurt, like chicken soup. All right. Now, I love the question about do you have an accountant or tax preparer or bookkeeper? Good question in many situations. List all of your current or anticipated monthly expenses. I think for both custody and child support, this is right on, because one of the main ways that we get, the way that we can set income without income documentation is to force based on expenses. We can list out this person, take their bank statements, cancel checks, and credit card slips, and reverse engineer what they make based on what they spend, as opposed to what they claim they make. So one of the big phrases you see in my forensic accounting desk book, the difference between claimed and actual income. So listing all the current and anticipated expenses would be great to have. Are you incapacitated in any way? Do you have any mental health issues, alcohol abuse, that sort of thing? Very good for custody, obviously. Maybe even good for child support, because if the other party is going to claim that they can't work, this interrogatory is going to matter a great deal. So negotiations for the sale of assets, probably not relevant unless you want to argue that the party has a lot of real estate and deals in real estate transactions regularly. There are income items. There are places where parents can earn income that is not taxable. Namely, let's say you own a house or you own a condo in Gulf Shores. You paid $200,000 down. It was $400,000 at the time you bought it. You sell it for $500,000, and you make $100,000. You can roll that over through a tax-free exchange pursuant to IRS regulations, so that the next property's basis is $200,000. Not that complicated. And so there are times we need to know about income that may not show up on a tax return. Safety deposit boxes is interrogatory 27. No, we don't need to know that. Now, interrogatory number 28. Have you taken any vacations or trips within the past year? If so, where did you go with them and what were your expenses? Great question for both. Okay. People like to spend money on trips. Who doesn't? But if you don't have any money, or you're claiming you're poor, but yet you're going on a lot of these junkets with your boyfriend, girlfriend, employer, whatever, that's a good question. Could be a great question for both child support and custody, or just child support. All right, now we're not going to go through all the requests for production documents. We have the same issue there. Now, what I want you to understand is within our system, we have lots of specific custody questions. Right? And we've talked about contention interrogatories. Well, we've got a bunch written down. And again, what I want you to do before you write post-divorce custody interrogatories and or requests for production of documents, we'll go over that in just a second, but the writing up of specific, case-specific interrogatories and requests for production of documents is art. All right? We have several pages of sample child custody questions. All right? Now, take a look at it in the computer. Maybe it jogs your thoughts about, or tickles a thought about the case that we're working on in specific. Tailor it for there. But again, you got to think through: do you want to ask this at a deposition, or do you want to ask this at in interrogatories? And if it looks like you may not have the budget, or otherwise not going to have depositions, it should be pretty obvious. Let's go ahead and ask it on the interrogatory. Okay. And or if we issue less than 30 interrogatories, we can go back and amend and issue a second set. Not that complicated. Now, on the request for production of documents, in terms of what's general or standard, I do, number one, love the catch-all document request. And this is really why we need to issue RPDs in just about every case. I can't imagine a case that I don't want to send out RPDs on. Other than these documents, other than those documents specifically requested below, all documents, photographs, letters, statements, recording, or tangible things pertaining to the facts of this case that would support you or your former spouse's positions, including but limited to grounds or economic issues. Obviously, turning that over into a custody or child support related question is pretty easy. Request number two, all documents showing your income. Again, we're going to use that on both. And then all documents evidencing current income from any source other than those identified above. So those are your general, before we get into super specific requests for production of documents. But again, so attorney's fees, we do have a request for production of documents that's specific to attorney's fees, and that's going to request the opposing party's contract with their lawyer, the invoices, and related documents to how much that person actually paid of their fees, how much they were charged. And we may need that both as an offensive tactic and possibly as a defensive tactic on our end. If we represent the more propertied spouse, the other side may or may not come forward with a really aggressive fee application, but we won't know that until really opening statements. Okay, they could bury the fact that they've got hundreds and hundreds of pages of documents they're going to hand the judge in a fee application. All right. But again, case specific for requests for production of documents on custody. Okay, do we ask for email, text messages? Do we ask them to download their Facebook page? Does the opposing party live on Instagram? What do we got to do to go get all the Instagram postings? Hopefully find something in there that's inappropriate for a parent. That sort of thing. What do we want to do? what's the best way to think about case-specific interrogatories and requests for production of documents? Well, hopefully from day one we've started thinking about and writing down ideas for themes and theories of the case. And if one of our theories is that the father is inappropriately sexual with group X, or all women, or this or that, well, where are we going to look? We're going to look at social media, we're going to look at email, we're going to look at possibly even an employer subpoena. See if the person has been reprimanded at the office. We had a case once many years ago where a father took photos of coworkers, female coworkers' body parts, and then bragged about it later. So I think the big thing this guy liked was leggings. It's a little bit creepy. Is that something that could come in a custody battle? Sure. If you have to go to court. If you're not going to court, maybe it's just put in and shared with a mediator. There's 100 ways that you can go about using something like that, or just hold it for trial. Who knows? All right, that's the lead counsel lawyer's decision that should be made in consultation with the client, okay? Because there's reasons why you wouldn't want to put that in the public domain. And what if the father, you go to mediation, and say in that case the father was seeking more parenting time post-divorce. He has 100 nights, and he asks for 50-50 time. You go to mediation, and the mediator comes back 125 would be great. And if mom's okay with 125, you're done, and you don't have to mention photos on a cell phone. Okay. How do we learn about something like that? Because somewhere, in that case, the father bragged to somebody they shouldn't brag to. Okay. And none of it's illegal, but it sure is creepy. Okay. And so we run into a lot more creepy facts than we do illegal facts in our business. All right. So, case-specific interrogatories, requests for production of documents. Number one, we just talked about. All right, themes and theories. Number two, talk to your client. Tell them what you're doing and say, do you have any ideas for me who I should talk to, or who's going to know the smoking gun? All right. If it's an employer, then we can do something with the subpoena. If it relates to an expense that was inappropriate, well, we may want to make sure that we get issue a subpoena to a credit card company. Maybe it'll work, maybe it won't. Who knows? All right. But that's where our advocacy comes into. Anybody can put together interrogatories and requests for production of documents that are generic and simple. Now, generic and simple isn't terrible. Don't get me wrong. It's better than nothing. But I like to see case-specific interrogatories and requests for production of documents depending upon the strategic posture we want to make in the case. It's that simple. So generic and simple may be the right call in 50% of our post-divorce custody and or child support matters. Okay? That's it for my presentation.